welcome to the HUD Office of Public and Indian Housing training on the Violence Against Women Reauthorization Act of 2013, or VAWA for short. I'm Ryan Jones, a Senior Housing Program Specialist in the Voucher Management and Operations Division of the Office of Public and Indian Housing, or PIH for short. I'm joined by my colleague, Miranda Stern, a Housing Program Specialist in PIH's Public Housing Management and Occupancy Division. We're happy that you're able to join us today. Today's training is being provided in 5 parts. Within each part are a specific set of topics that we will cover. This training was built around the guidance in PIH's Notice 2017-08 titled Violence Against Women Reauthorization Act of 2013 Guidance. The guidance was published on May 19, 2017. As we proceed, you'll notice that the training agenda follows the order of the PIH notice. We've included the reference corresponding to the specific section of the notice on the top of each slide to the left of the slide's title. This way, after you've heard us speak on a specific topic, you can go back to that section and read for further details. In the first part of this training, we'll be covering the first 7 parts of the notice. We'll discuss the purpose of the training, the applicability of VAWA to the public housing and housing choice voucher programs, provide a brief background on HUD's implementation of VAWA, summarize the major changes as a result of the reauthorization of VAWA, highlight terms that are used throughout the VAWA final rule, and in the notice that you should become familiar with, speak to who may receive VAWA protections, and provide an overview of how VAWA protections are determined. We hope to achieve a number of important tasks in our time with you through this training. We will be providing a detailed overview of the requirements of VAWA in the public housing and housing choice voucher programs. This includes project-based vouchers, or PBV, home ownership, and the Section 8 moderate rehabilitation, or MOD rehab. As we move through the material, we will be calling out the responsibilities and obligations of PHAs and owners. For example, where only the PHA has an obligation under VAWA requirement, we'll make note of that. We'll explain the VAWA forms that were included in HUD's VAWA final rule, including which are mandatory or may require that the PHA tailor the forms. Finally, throughout the training, we'll be providing some context to the material by talking through some sample scenarios. Miranda, would you mind providing the audience with some background to help us contextualize how we got here?
Absolutely. Before I start, I want to thank the audience so much for joining us today as we discuss this important topic. Okay, so for context, especially those that may be new to VAWA, I'm going to go back a little further in the timeline because the 2013 reauthorization isn't the first time that our PHAs and owners had obligations and requirements to protect victims of domestic violence. On March 7, 2013, VAWA was signed into law. We'll call it VAWA 2013. VAWA 2013 reauthorized and amended VAWA 1994, which was previously reauthorized by VAWA in 2000 and 2005. It was the VAWA 2005 reauthorization that brought HUD's public housing program and HUD's tenant-based and project-based Section 8 programs under coverage of VAWA by amending Sections 6 and 8 of the United States Housing Act of 1937. VAWA 2005 established that being a victim of domestic violence, dating violence, or stalking cannot be the basis of denial for assistance or admission to public or Section 8 housing and provided other protections for victims. VAWA 2005 also contained requirements for notification to tenants of the rights and protections provided under VAWA and provisions on the rights and responsibilities of public housing agencies and owners and managers of assisted housing. In addition, it contained provisions pertaining to acceptable documentation of incidents of domestic violence and related acts, and maintaining confidentiality of the victim. All concepts you will see carried forward in the reauthorization. HUD implemented these provisions through rulemaking with the regulations pertaining to VAWA 2005 protections, rights, and responsibilities were codified in 24 CFR Part 5, Subpart L. That brings us to the passage of the VAWA reauthorization in 2013. HUD issued a Federal Register notice that sought comment on implementation in HUD programs. PIH issued a letter to PHAs on September 30th, 2013, summarizing the Federal Register notice. HUD commenced rulemaking, issuing a proposed rule on April 1st, 2015. HUD issued a final rule on November 16th, 2016, which amended 24 CFR Part 5 and numerous program-specific regulations. And finally, as previously noted, PIH issued Notice 2017-08 on May 19, 2017 for the Public Housing and Housing Choice Voucher programs. VAWA and HUD's final rule resulted in a number of significant changes. I'll go over 11 of them. Don't worry, as we will go into detail throughout this training. In my overview of this history, I said that VAWA previously covered domestic violence, dating violence, or stalking. Now VAWA also covers sexual assault. HUD clarifies non-discrimination and equal opportunity requirements. A number of definitions have been added, and other previously established definitions have been revised. In just a few moments, Ryan will highlight some of these definitions. The VAWA final rule establishes new requirements for notification of occupancy rights under VAWA and transmits a model notice of occupancy rights. It provides that tenants and applicants may not be denied assistance or have assistance terminated under a covered housing program on the basis of or as a direct result of the fact that the tenant or applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. It establishes the requirement to establish an emergency transfer plan, establishes record keeping and reporting requirements, and provides a model emergency transfer plan for victims of domestic violence, dating violence, sexual assault, or stalking, and emergency transfer requests for certain victims of domestic violence, dating violence, sexual assault, or stalking, which we will go into greater detail. It revises requirements for documenting the occurrence of domestic violence, dating violence, sexual assault, stalking, and provides a new certification of domestic violence, dating violence, sexual assault, or stalking, and alternate documentation, which we also call Form HUD 5382. In the case of lease bifurcation, it establishes a new requirement for reasonable time periods during which a tenant who is a victim of domestic violence, dating violence, sexual assault, or stalking may remain in the unit while establishing eligibility under the current housing program or under another covered housing program or seeking alternate housing. It revises various HCV, PBV, and public housing regulations from the 2000 Reauthorization of VAWA. It clarifies that PHAs may establish a preference for victims of dating violence, sexual assault, and stalking, in addition to domestic violence. And as the last of the summarized changes, it establishes new requirements under project-based vouchers for a family's right to move. Ryan, can you talk about some of the terms we'll most often use today?
Sure, thanks, Miranda. Before we move forward, I want to point out to the audience that there are a number of terms, both new and revised, used throughout the guidance in this training that can be found at 24 CFR 5.2003. I recommend pausing the training or making a note to go back and read the definitions of these terms. So let's start with the basic question of who is eligible for VAWA protections. Like the notice, this slide breaks eligibility into who is eligible and who is ineligible. Let's start with the left column, who is eligible. VAWA protections cover tenants and assisted families as defined under applicable program regulations. VAWA protections also cover applicants when they're applying for admission to a covered housing program. It's important to clarify that VAWA protections are not limited to women. Victims of domestic violence, dating violence, sexual assault, or stalking are eligible for protections without regard to sex, gender identity, or sexual orientation. Further, victims cannot be discriminated against on the basis of any protected characteristic, including race, color, national origin, religion, sex, familial status, disability, or age. and HUD programs must also be operated consistently with HUD's equal access rule. A clarification not listed here, but discussed in the notice, is that a PHA or owner may find instances of domestic violence, dating violence, sexual assault, or stalking against youth under the age of 18 living in an assisted household for which the family may need to exercise VAWA protections to protect the youth victim. In these circumstances, PHAs and owners should exercise the same documentation and confidentiality procedures in assisting a family in this situation. So we've said that tenants, assisted families, and applicants are eligible for VAWA protections. Now let's discuss who is not eligible. Guests, unassisted members, and live-in aides of the family are ineligible for VAWA protections that are available only to tenants and participants. On the slide, there's an asterisk that says reasonable accommodation. That's there for an important reason. As a reasonable accommodation, a tenant or participant can request VAWA protections based on the grounds that the live-in aide is a victim of domestic violence, dating violence, sexual assault, or stalking. So while we've said that guest or unassisted members are ineligible, in cases where a guest or unassisted member is a victim of domestic violence, dating violence, sexual assault, or stalking, a tenant or participant cannot be evicted or have assistance terminated on the basis of domestic violence, dating violence, sexual assault, or stalking of the guest or unassisted member. I should note that we'll briefly discuss reasonable accommodations within the VAWA context later in this presentation, and that the topic is discussed in the VAWA notice. So we've just covered who may receive VAWA protections. Now let's discuss eligibility. Stick with me here. The VAWA final rule provides that an applicant for assistance or a tenant or participant receiving assistance under a covered housing provider may not be denied admission to, denied assistance under, or terminated from participation in, or evicted from housing on the basis or as a direct result of the fact that the applicant, tenant, or participant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, if the applicant or tenant otherwise qualifies for admission, assistance, participation, or occupancy. In addition to prohibiting a denial, termination, or eviction based on the fact that the applicant, tenant, or participant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, covered housing providers are prohibited from denying assistance or admission, terminating participation in, or evicting a tenant based on an adverse factor if the adverse factor is determined to be a direct result of the fact that the applicant is or has been a victim of domestic violence, dating violence, sexual assault, or stalking. As we move forward, we'll explain the direct result in the context of an adverse factor. Adverse factor is a new term, so let's define it now. An adverse factor refers to any factor that can be used as a basis for denying admission, terminating assistance, or evicting a tenant. Note the second bullet on the slide. However, if a denial or termination of assistance or eviction is required by a federal statute based on particular adverse factor, the PHA must comply with that statute, even if the adverse factor is a direct result of domestic violence, dating violence, sexual assault, or stalking. For example, if the applicant is subject to a lifetime registration requirement under a state sex offender registration program, the PHA must comply with the Quality Housing and Work Responsibility Act of 1998 and deny the applicant admission, even if the sex offense or offenses were a direct result of the fact that the applicant was a victim of domestic violence, dating violence, sexual assault, or stalking. So let's say one more time to let it sink in. Let's say it again. An adverse factor refers to any factor that can be used as a basis for denying admission, terminating assistance, or evicting a tenant. On the surface, adverse factors may appear unrelated to domestic violence, dating violence, sexual assault, or stalking, and may present legitimate reasons for denial, termination, or eviction. However, the presence of an adverse factor may be due to an underlying experience of domestic violence, dating violence, sexual assault, or stalking. An adverse factor may be present during much of an abusive relationship, or it may present itself only when a victim is attempting to leave or has left the abusive relationship. On the following slides are examples to give PHAs and owners a sense of the many instances in which adverse factors might be the direct result of domestic violence, dating violence, sexual assault, or stalking. Please note that this list is neither exhaustive nor definitive. Here we have 4 examples of adverse factors. These examples are covered in great depth in the notice at section 7.2. So we have poor credit history, poor rental history, criminal record, and failure to pay rent. So what may lead to a poor credit history, as an example, may be forcing a victim to obtain credit, including credit cards for the perpetrator's use. Early lease termination and/or short lease terms may be the result of fleeing domestic violence, which may result in poor rental history. Property damage may have resulted from the abuse of the victim in a criminal record, and a lost wage or lost job may have been a result of missing work to attend court hearings, seek counseling or medical care, or deal with other consequences of the crime. I recommend reviewing the notice for more detail, as some of the examples may not be apparent to those of us that may not have experienced this type of violence or worked with those that have. Miranda, can you discuss how to determine if an adverse factor is a direct result of domestic violence, dating violence, sexual assault, or stalking?
Yes. So that begs the question, how do I, the PHA or owner, determine if an adverse factor is a direct result of domestic violence, dating violence, sexual assault, or stalking? To trigger the direct result analysis, it is the responsibility of the applicant or tenant to inform the PHA or owner that they are a victim of domestic violence, dating violence, sexual assault, or stalking, and provide enough information for the PHA or owner to make a determination regarding the adverse factor they are claiming was a direct result of domestic violence, dating violence, sexual assault, or stalking. After the PHA or owner receives the information, the PHA or owner should consider the individual statement and any possible supporting documentation in determining if an adverse factor was a direct result of domestic violence, dating violence, sexual assault, or stalking. If the PHA or owner believes any information is not clear, it should speak to the victim and try to clarify the information. If further information is necessary for this determination, the PHA or owner may request additional supporting documentation from the applicant or tenant. However, any request for additional documentation must be in accordance with the PHA or owner's policies or practices, not require evidence of the domestic violence, dating violence, sexual assault, or stalking other than as specified in 24 CFR 5.2007. You may also see Section 8 of this notice. And not violate VAWA's final rules, confidentiality requirements, or any other laws. It is important to note, an applicant, tenant, or participant fails to request VAWA protections, the PHA or owner is not independently required to identify whether adverse factors are the direct result of domestic violence, dating violence, sexual assault, or stalking. After the PHA or owner has received the information from the tenant or applicant, and, if necessary, clarified this information with the tenant or applicant, the PHA or owner must make an objectively reasonable determination, based on all the circumstances, whether the adverse factor is a direct result of the fact that the applicant or participant is a victim of domestic violence, dating violence, sexual assault, or stalking. PHAs and owners must notify the applicant or tenant if the denial, termination, or eviction is not on the basis or as a direct result of being a victim of domestic violence, dating violence, sexual assault, or stalking. And the applicant or tenant is thus denied admission to, denied assistance under, terminated from, participation in, or evicted from the housing. An applicant or tenant that disagrees with the finding should use the program's appeal procedures, if applicable. In the case of a termination or eviction, PHAs and owners must comply with the prohibitions which say that the covered housing provider must not subject the tenant who is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, or is affiliated with an individual who is or has been a victim of domestic violence, dating violence, sexual assault, or stalking to a more demanding standard than other tenants in determining whether to evict or terminate assistance. So even if the direct result prohibition does apply, the PHA or owner cannot use that violation to terminate or evict a tenant who is a victim of domestic violence, dating violence, sexual assault, or stalking if the covered housing provider does not ordinarily terminate or evict tenants for that violation. So that concludes the first part of our training. Please stay tuned for part 2.